One of the things about our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hello, everybody, and welcome to the show. Today, we're talking about agreements for sale. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, X, formerly known as Twitter, and you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, you can download an audio version of the podcast. You can find it on Spotify, Apple Podcasts, or any other podcast platform. Download it, give us a review. We'd appreciate it. That would be awesome. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is the risk and benefits of using leases with options to purchase to acquire an interest in real estate. So what are the risks and benefits? So let's start first with the benefits of acquiring property using a lease with an option to purchase. So one of the benefits of this is if you do a detailed review or analysis of different due on sale clauses, you will see that there are certain due on sale clauses that do not expressly prohibit leases or options to purchase property. So one of the benefits is you can enter into a lease with an option to purchase without violating certain due on sale clauses. Another benefit is even if it falls within the due on sale clause, most of the time lenders are not going to invoke the due on sale clause as a result of some form of either option to purchase or purchase contract. Plus, federal law provides that if the primary loan or the loan against the property is a federally insured loan, then the borrower / homeowner can enter into a lease for up to 3 years for the property without violating the due on sale clause. As long as, and this is the caveat, right? As long as it doesn't have a corresponding option to purchase. Well, okay. So what you do is you enter into a lease, and instead of doing an option to purchase, you do a purchase contract with an extended escrow that has all the same terms you would find in the option. And you record a memorandum of that purchase contract. I've never once seen a lender invoke their due on sale clause because a memorandum or affidavit of the existence of a purchase contract has been recorded against the property. So that's the benefit of that type of transaction. It makes a seller feel more comfortable because title hasn't transferred, and it is not as likely to fall within or create an issue with the due on sale clause. So what are the risks with this type of transaction? So the first risk with this type of transaction is that, and it's not really a risk, it's just a detriment, is you don't have all the same tax advantages generally as you would under a traditional wrap with warranty deed purchase or even an agreement for sale. You don't get to claim the mortgage interest deduction, nor do you get to depreciate the property. So you don't get those types of tax benefits. So that's one disadvantage. The other risk or disadvantage is it's not bankruptcy proof. It's subject to bankruptcy. So if the seller, not really the seller, the landlord, the lessor, the optionor, if they go in and they file for bankruptcy, the trustee can generally come in to the bankruptcy court and set aside that lease. They can say, hey, look, that property has value. We don't like this lease. We don't like this option to purchase. So we're going to set it aside. Now, it's not just like all of a sudden, like, oh, you're out. The trustee would have to take the steps to put the parties back into what we call the, status quo. And what that would mean is, for purposes of the option, any option fee or amount paid, for rent credit or otherwise that would go to the option and for towards the purchase price, the trustee will have to, pay and reimburse the optionee that amount, but then they could terminate the lease and the option to sell the property and take the proceeds from that sale and distribute it to the creditor. So that's really, a negative, a downside for this type of transaction. But if there's an issue with the due on sale clause and, you're trying to, meet lender requirements or even meet seller's concerns, and lease with an option to purchase does provide the greatest, protection from the due on sale clause. However, it doesn't come without risks and detriments.
All right. Thank you, Sean, for the legal update. With that, let's get into a few announcements for the INREM podcast. A reminder, every Tuesday at 3:00 p.m., we have our Creative Finance Collective. What is that? That is an hour-long meetup of professionals, mainly attorneys in the space of creative finance. And these attorneys meet up with us from a variety of different jurisdictions. We've had lawyers consistently from Texas, Alabama, Georgia, Arizona. We've had lawyers from California. They come from all over the place, and there is really kind of a niche group of lawyers out there that focus on creative finance. So there's not a lot of them, but they get together and we talk about creative finance, what lawyers are doing with respect to creative finance in different states, how they're handling the transactions, what laws are being passed. But what we do is make that available to you, the listener, and we make ourselves captive for the hour or until we stop receiving questions. So that is an awesome opportunity for you if you're interested in kind of fleshing out what it would look like for you to understand and get involved in the creative finance world. It's an awesome opportunity to ask questions and or get answers to questions that you have. So make sure to join us 3:00 p.m. every Tuesday at Arizona time. We'll see you then. You can find it on Facebook or YouTube. Also, a reminder, we're going to take questions throughout this episode. One of the things we'll do a little bit different, if you have a question, just post it, and we'll try to get to it throughout the episode. If you've got a question about our topic, we want to interact with you. So we'll try to take those as they come. With that, we're going to go ahead and get into our topic today. As you may have noticed in my introduction, I talked about agreements for sale, but our thumbnail talks about industrial real estate. We had intended to talk about industrial real estate. We had issues with our guest being able to get here to do that. So things changed. That's show business, baby, as they say. So we're going to move on, and we're going to talk about a topic that we find intriguing. It's a topic that we've been talking a little bit about in some of our past episodes. Sean, you've devoted a good bit of your legal updates to fleshing out agreements for sale. But what we wanted to do is kind of do a deep dive into agreements for sale, and beyond that, kind of give you a picture of what agreements for sale might look like in different states. Now, we can't do that for all the states. There's 50 of them, and that means 50 different sets of laws. As we know from being on the collective, if you've joined us on the collective, there's some states that treat agreements for sale very differently than others. So this is a very state-by-state thing. But with regard to Sean and I, we come at this as licensed attorneys from a couple different states, mainly Arizona and Wisconsin, and both of those states treat the law of agreements for sale differently. So we want to give you kind of a picture of what you could theoretically expect or run into when dealing with agreements for sale. But Sean, as we approach this, and I know we've done this in some of the legal updates, but we should really just do it here to set the stage. What are we talking about for the listener who's just joined us when we say an agreement for sale? What is that?
So an agreement for sale, which is the term we use in Arizona, is also known as a contract for deed. a land contract, a land installment contract. It has a number of different terms throughout the country and in different states. So in Arizona, we use agreement for sale. In Wisconsin, we use land contract. But it basically is the same thing, which is title remains in the name of the seller, and they're called the seller in the document. They're referred to as the seller. The title remains in the name of the seller, and the purchaser agrees that they will make payments to the seller or on the seller's behalf over a period of time. And then when they fully perform under the agreement or the contract, they will then acquire full fee title to the property. So a warranty deed at that point will be recorded, and they will then have title to that property. However, there's a few, even though title doesn't transfer, the purchaser has the ability to basically use the property as their own. They have the ability to improve the property, to maintain the property, to lease the property, to occupy, possess the property, to pay property taxes, to pay insurance, to basically do everything with the property that any other owner can do. The only difference is they are not the record title holder of the property until they fully perform under the agreement for sale. However, they do have a recorded interest in the real estate because the agreement for sale or land contract is in fact a recorded document and gets recorded with the county recorder's office so that the world is aware of the purchaser's interest in the property. And it also locks the purchaser's interest in as of the date of that recording, meaning let's say the seller later on wants to go get a line of credit or a loan against the property, or even tries to sell the property. Well, good luck, because the purchaser has now locked in their position, their right, their interest in the property as of that date. And anybody trying to acquire a subsequent, lien interest or ownership interest in the property after that date takes it subject to whatever claims and rights that purchaser has. So it's important that it's also recorded with the county.
So Sean, as I'm listening to this, I'm trying to put myself in the shoes of a listener who's maybe done owner carryback financing, which is really what this is a form of. And I'm thinking, okay, this sounds interesting. What do I need to do with my promissory note and deed of trust that I'm used to using in a carryback transaction? How do I use that in an agreement for sale?
Put it in the waste paper basket. It's no good in an agreement for sale land contract, because the nice thing about an agreement for sale or land contract, and the way I draft them, is it is your everything in this transaction. And what I mean by that is it is your purchase contract. It is your promissory note. It is your deed of trust or mortgage. It is your conveyance document. It is everything all wrapped up into one single document. So basically the way that this would work from a practical sense, and then we should talk about assignments a little bit later here, both before closing and after closing. But the way this operates is you take the agreement for sale to a seller, just like a purchase contract, and it flows very similar to a purchase contract that has all the creative finance and subject to and wrap financing terms in it, and it flows. And then you as the purchaser execute and date the agreement for sale, and the seller then executes and dates the agreement for sale. And at that point in time, signatures do not need to be notarized. You just sign it. Then you take that fully executed agreement for sale and you deliver it to your favorite escrow agent or title company, or the one that will do the transaction properly. And you deliver it to them and you open escrow. Then you have an inspection period, and you have everything else that you would find under a regular purchase contract. Then the way escrow closes is you go through everything. You get a title commitment. You make sure that everything, works on the title commitment. And then, and we can dive into the weeds a little bit, but right now we won't dive into them. And then what happens is, to close escrow, the money comes in, whatever, cash at close, earnest money, it's all in just like a regular purchase contract. But to close escrow, what the title company will do is they will fill in the final purchase price. And that's important, at least here in Arizona, because that determines our redemption period, or not redemption, but your waiting periods to actually do a forfeiture. But the title company fills in the final purchase price, has the parties initial that on the document. And then they have the parties notarize the agreement for sale. So you're going to have two sets of signatures. You're going to have your unnotarized signatures and your notarized signatures. Once you get the notarized signatures on that agreement for sale, then the title company records the agreement for sale and distributes or disperses the closing proceeds. That is closing. And it basically goes the same as a regular purchase contract. And now you've closed the transaction. You've not executed a deed of trust. You've not executed a promissory note. And you may have executed a warranty deed, but we'll get into that a little bit later. If the parties are using a servicing agent, we can talk about why it's important to use a servicing agent. But you may have that, but the warranty deed never gets recorded. That gets recorded later on when there's full performance. So, but that's it. And, an experienced escrow agent, they know how to do this. They know how to process these transactions and to close escrow on them and what documents need to be signed. So, but I like it because, man, it's kind of an all-in-one thing, and it's pretty simple and straightforward.
Now, if I'm the buyer here, and I'm going to do this in a conventional transaction, when I pay off my loan, I'm rewarded with the removal of the bank's lien or the lien holder's lien, and I own my property free and clear. In this case, when I make my final payment, I'm rewarded with legal title of the property. I get it by deed. Is that right? So how, as the buyer, because I would think in this transaction, in any real estate transaction, gee whiz, the deed is golden. I want to make sure that I get that. If there's a long term on this loan and how much money I'm paying, what can I do to ensure that I do in fact get that deed at the end?
It is, in my view, critical. And I think it's critical no matter what style of transaction you do, for especially, any type of seller carryback or subject to financing or transactions. It's critical to put a servicing agent in place. And the reason why you want to do that is because you want to make sure that your money goes to the servicing agent. They then write the check to the existing lender if it's subject to, or they write the check to the seller if it's, a straight seller carryback. But they take the original warranty deed from the seller and they hold that original warranty deed so that if there is full performance, then at that point, they can just record that warranty deed. And you don't have to worry about tracking down the seller. You don't have to worry about trying to get the warranty deed from them. It's also important on assignments, but I'm going to give you some horror stories here about what happens when this isn't done and done right. So I've seen numerous transactions, one of which, my client was trying to sell it wasn't even my client. It was the estate of my client was trying to sell the property. And my client, I guess, was the estate. Let me just clarify. I represent the estate, but the party to the agreement for sale was the deceased. They were the purchaser. And so I represented the estate, and they were trying to sell this property. Their mom had lived in this property for 40 years and had purchased it by an agreement for sale and, paid off the agreement for sale 20 some years ago. But guess what? The warranty deed never got recorded. And so now the estate's trying to sell the property. And now I'm having to look back at a 40-year-old agreement. That's how long these have been, these types of agreements for sale. They've been doing them for ages.
Yeah.
So I had to look back 40 years at this agreement for sale and then I had to find out who the original, seller was. And then of course they're no longer alive. So then I have to do research, and there's ways of doing it. And I have to do heir research on them to figure out, well, okay, did they do a probate? Who's next in line? Finally, I was able to track down the heirs. And miraculously, I was able to basically convince the heirs that, hey, you need to just release this thing because we don't want to have to name you in a lawsuit, whatever. It's clearly been paid off, blah, 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 blah. And they did. And so we were able to, work with the title company to figure out what documents they needed the heirs to sign to make them comfortable and, get the title actually back into the deceased name so that the estate could go and then, sell the property. But it took months. It wasn't a simple process. It wasn't like just, going, picking up the phone, sending an email and getting a warranty deed. It was a process, and it delayed closing and whatnot, but we were able to do it. But it was expensive too. It wasn't cheap. We have attorneys and paralegals and people working on this to try to figure all this out.
Right.
So that's one. The second horror story is an assignment situation where, you have an agreement for sale that allows for it to be assigned. So the purchaser wants to assign it to a third party, and they have the full right to do so under the purchase contract. Okay. However, the end purchaser wants to set up servicing so that when they perform, they can then own it. And so the way that would work is 2 warranty deeds would be delivered to the servicing agent. The warranty deed from the original seller to the initial purchaser under the agreement for sale, and then the warranty deed from the purchaser under the agreement for sale to the assignee who they're assigning it to, so that they deliver those to escrow so that when the assignee fully performs, they will have title. So we go back to the original seller because there wasn't that warranty deed out there, and we say, hey, we need to get this, as required by the contract, because we're going to put it with a servicing agent. And that's what the agreement says. And the seller basically said, the only warranty deed I need is the one back to me. And they wouldn't provide it. Yeah. Well, what do you do then? You can go to court and whatnot, or, the assignee can close on it, but then they know that, when they do, they're going to have to file a lawsuit against the original seller to quiet the title. And it's a whole mess, right? So it's not a simple process. So it's very important, in my view, to use the servicer to put that warranty deed on deposit with that servicer. So you can either, perform and sell that property, or perform and pay off the loan and have title. You can sell the property to a third party and pay off the loan, or you can assign the agreement for sale without any difficulty. So it's critical, in my view, to use that servicer.
I like the word that you use there, critical, and the reason I'm pointing this out is critical shouldn't be confused with required. Right. And of course, this could depend on what state we're talking about. Right now, we're talking about Arizona. When people hear required, I think they assume that, if I'm using an escrow company, well, they're just going to do what's required, right? And I don't need to think about this, and it'll just get done correctly. Well, a notes or a servicer is not a requirement in an agreement for sale in Arizona. It is a best practice. There are legal reasons why you do it, but it is not a requirement. And if you don't take the steps to do that or negotiate that as buyer and seller, you're not going to have one. And then you inevitably run into these problems, right?
Right. Yeah. And that's why it's important. And it's important even in Wisconsin or any other state that you're doing this transaction, because you want that neutral third party that's licensed, that's been, approved by whatever state they're operating in or servicing loans. You want them to be the ones to hold that paper, because it's just going to make your life as the initial purchaser so much easier. It's going to allow for, greater disposition options. It's going to allow for no title issues if you go and you pay off that underlying debt or obligation, it just makes it smooth. So it's so important, even though it's not required, it's critical. And you're making a mistake if you do, frankly, you're making a mistake if you do any subject to transaction or any seller financing without a loan servicer, in my view. You don't legally have to, but it's a bad idea.
So I know you've mentioned on previous podcasts, and we'll deal with Arizona first in this regard, but in some of the Western states where your conventional carryback type of financing involves conveying the property and taking a lien pursuant to a deed of trust, which can be foreclosed non-judicially in the form of a trustee sale, and nowadays sometimes that doesn't even take that long. So we're not talking about a super long and drawn out process in a non-judicial foreclosure state. Is in those states, in your mind, is the agreement for sale the preferred way to transact a carryback financing deal, whether it's a sub two or just kind of just a conventional carryback?
It's preferred for a sub two, at least here in Arizona. In my view, it's preferred as a sub two. I don't like it for straight seller carryback, where you don't have to worry about any due on sale clauses. But here, I like the agreement for sale. For example, the VA, you can do agreements for sale, and title will insure it. And the VA's, published basically, in their handbook saying, yeah, we don't consider that to be an alienation of the property. I've never heard of a lender calling a loan due because of an agreement for sale or land contract for deed, because title is still remaining in the name of the original borrower of the property. So agreements for sale would be my preferred way of transacting here in Arizona for subject to transactions. If it's a straight seller carryback financing arrangement, I would prefer to do a wrap, not a wrap. It would be straight seller carryback, a warranty deed with a promissory note with a deed of trust on straight seller carry. And the reason is, and this was in my legal update as well, one of the risks of an agreement for sale is a lack of bankruptcy protection. That's a risk. And so on a warranty deed transaction, assuming that you get by any type of voidable preference period, and then, thereafter during a 1-year period that, it was a bona fide transaction, then you're fine. Anything after that 1 year, you're really in good shape. You're well protected. But an agreement for sale is not the same because it's an executory contract. So the trustee could come in and say, okay, how much have you paid? What have you been paying monthly? What's the fair rental value of this? And they come up with a whole formula, and they figure out how much to give you to basically unwind that transaction and put the property and all interest in the property back in the seller, so that the trustee can pull that property over to the bankruptcy estate and sell it so that the funds could be, distributed to creditors. So I say all that to say an agreement for sale is good on subject to, and I think the bankruptcy risk is, fairly minimal. And I wouldn't really concern myself with it. Just know it's a risk, but you have greater protection against due on sale. But if it's just straight seller carry, no. Do the warranty deed with the promissory note and deed of trust or mortgage, depending on what state you're in.
Now, I know that a lot of folks in Arizona, a lot of sellers like the idea of agreement for sale because in their mind, they believe that they can get the property back faster in the event of default. And the procedure here in Arizona, as opposed to foreclosure, is called forfeiture.
Mm-hmm.
Why don't you flesh out the requirements in Arizona of what forfeiture looks like, or a seller's different options to recover their property back?
Yeah. So for a forfeiture in Arizona, there's two types of forfeiture. There's judicial forfeiture, where you have to actually file a lawsuit and have the court declare the forfeiture. And then there is forfeiture by notice, which is outside of the court system. You can pursue judicial forfeiture for any type of agreement for sale, regardless of whether there's a loan servicer or not. You can always do judicial forfeiture. However, if the parties have installed and put a loan servicer in place, then the seller has the right to do a forfeiture by notice, which is outside of the court system. It's expedited. It's not as costly. You don't have to file a lawsuit. You don't have to serve the complaint. It's just completely outside of the court system. The timeframes for forfeiture depend upon the amount of the purchase price that has been, or a percentage of the purchase price that has been paid, which is why I indicated earlier that it's important to know that final purchase price, right? So what's the final purchase price, which includes, if it's subject to, the loan balance as of the time of the sale. And you may not know that when you're sitting at the kitchen table with the seller filling out, the agreement for sale and just having unnotarized signatures. So, you might have a rough estimate, but you don't know the final amount. So the title company fills in that final amount. So the final purchase price, the final amount, it's the percentage that's been paid. So from 0 to 99.9%, if you're within that range and you've only paid that much, that percentage, then a forfeiture can happen upon 30 days notice. If you've paid 10% to 19.9%, then a forfeiture can happen upon 60 days notice. If you've paid 20% to 49.9%, then a forfeiture can happen upon 120 days notice. And then anything 50% or more, a forfeiture can only happen upon 9 months notice. So it's a significant time period if you've paid that much in towards the property. And it makes sense, right? I mean, this person has paid a lot towards the purchase of the property. And we're not going to allow them on a 30-day notice to just, take them out. They have 9 months to figure out what they're going to do to fix the problem, to save the property, to sell the property, to whatever they need to do to try to make themselves whole, because they've paid a lot to that purchaser, already. And so we're going to give them time to try to, make it up, to fix it, that type of thing.
Yeah. So if you're comparing timeframes as a seller and what is going to be most beneficial for you, deed of trust versus forfeiture by notice, those first two time categories are really going to be where, at 60 days, you're still under the 90 days notice of trustee sale period of time to do a non-judicial foreclosure. But beyond that, you could, like you said, be waiting a much longer period of time. So
Right.
it's important to know that. And of course, you go in planning. I don't know what the statistics are on a borrower, where they're at in the process, where they're more likely to go into default. But I suspect more often it's with the earlier stages of the loan. If they just miscalculated whether this is the kind of loan that they could afford or whatever else, versus somebody who's 95% paid off and is that's less likely to go into that. But planning for that is going to be important. But in terms of real estate recovery, that 30 or that 60 days, that's lightning fast in the world of
Right.
recovering real estate on default, right?
Yes. Oh yeah. That's lightning fast. I mean, I think, we do the collective with a couple of attorneys from Texas, and I think Texas is really fast, but outside of that, I'm not aware of, being able to do something, some type of remedy where you get the property back in less than 30 days.
Right. So that can be a valuable tool, and understandably something that a lot of sellers would be attracted to. But you said it there, for them to take advantage of that, they have to use a note or an account servicer, right? Otherwise, they're
Mhm.
doing forfeiture by a judicial forfeiture, which is a
Correct.
lawsuit.
Right. That's exactly right. And now you're wrapped up in the court system, and that case, it can only move as fast as the court will move. And, at least in Maricopa County, I mean, I think we're fairly quick compared to the rest of the nation, but it still seems like it moves at a snail's pace.
Yeah. Now compare that with Wisconsin. Sean, you're also licensed in Wisconsin. Not every state is going to provide that. Many states may provide the option of an agreement for sale. They may call it different things like a land installment contract or a contract for deed, but many will allow it, but not all are going to be similar in your remedy and how quick or fast they'll allow you to recover. Are you able to, on notice in 30 days, achieve a forfeiture of real estate in Wisconsin?
No, unfortunately, Wisconsin is and we don't, in Wisconsin, we don't call it a forfeiture. We call it a foreclosure. So on a land contract, you can do what's called a strict foreclosure, which means you either get an order from the court setting the redemption timeframe, but that's after you filed and served and, all of that, has occurred and the time to answer has gone by, or you get a judgment which sets the redemption time frame, and the judge can do the redemption no faster than 7 days, but they could do it longer too than that. And so, but you still have to file the lawsuit, go through that process. And so, you're probably looking 60 to 120 days at the earliest, maybe longer, plus, more expenses and costs to be able to do a strict foreclosure. And a strict foreclosure in Wisconsin means that you're not going to pursue any deficiency rights. You just are trying to take title to the property back. So you're going to just get the property back and then keep whatever's been paid. And that's it. You're not going to say, okay, well, you agreed to pay me $300,000. I took the property back. It's only worth $200,000. So I want $100,000. If you want to pursue that type of foreclosure where you preserve your deficiency rights, it's going to be a much longer redemption, much longer process. And Wisconsin's not alone. I think Arizona's
probably pretty unique in that regard.
Yeah. Without having done a 50-state survey, all the other states I've come across that have contracts for deed or land contracts, which they all do, but, I'm not aware of any other state besides Arizona that allows for forfeiture by notice outside of the court system. Maybe somebody's listening can correct me and say, oh, I'm in a state that has it, but I'm not aware of that.
Now, the differences in remedies between the various states notwithstanding, there's obviously going to be differences that you want to factor in. The benefits that you previously discussed with regard to buying sub 2 and the risk that you discussed associated with bankruptcy, those don't really change depending on the location, right? You're dealing with the same bankruptcy laws for the most part. That's a federal law.
Mm-hmm.
And so you're going to have similar risks as it relates to that. But when you talk about, alienation clauses or due on sale clauses in the VA or others, you're going to find those clauses to be similar and or the same depending on what state you're transacting in, right?
That's correct. Now, while I've never seen the due on sale clause invoked for an agreement for sale or land contract,
doesn't mean it can't.
Doesn't mean it can. And when so for example, in Arizona, most loans are originated through mortgage brokers, and we have big, mortgage broker entities and companies in Arizona, and they're all over the place. And, you can find their offices at different, office parks and things like that. And they have, hundreds, if not, thousands of loan originators that work for them. In Wisconsin, it's a little different. We still have mortgage brokers or loan originators, but a lot of the loans are done through small community banks here, unlike Arizona, where that doesn't really happen. We don't really have many. We have some credit unions, but not really any small community banks. But in Wisconsin, there's a lot of small community banks. Well, they're a lot more particular on their loan servicing, on their, loan portfolio. And so they, very well will not appreciate or like the idea of a land contract and the borrower giving up, all rights to the property, but the right of title. And so, that's something to consider, and that is going to change, across state lines. And the majority of loans in Arizona are all going to be securitized, Fannie Mae, Freddie Mac, FHA, VA. You don't have really too many, small lenders that are going to hold their own paper and service their own loans versus the Midwest, like Wisconsin. You're going to see a lot more of that.
So agreements for sale are an interesting strategy with regard to creative finance transactions. But as we discussed, it's a different transaction and different documents. There's no promissory note. There's no deed of trust. There's no mortgage. You have the agreement for sale. So given that, and given that maybe an investor or somebody wanting to get into using agreements for sale might be used to their forms that had everything that they'd carved out in their note, deed of trust, so on and so forth. What are important provisions in an agreement for sale that you think need to be there, especially if you're using it for a creative finance transaction, or what should the investor be thinking about?
So the two most important provisions are, and this is the most important, is an assignment provision, which allows for the agreement for sale to be assigned either before closing or after closing. And so you think, okay, so you can wholesale agreements for sale, which is cool. And so you have a signed agreement for sale, you can wholesale. And the way you would do that is you would assign your interest prior to closing to a third party. And the way you would document this, because the agreement for sale is already signed, right? And you don't have a subsequent, warranty deed or other document out there. And so the way that this would happen is you would assign it to the end purchaser prior to closing, and you would do an assignment, but you would do a form that's called a notice of assignment of agreement for sale. And that would then be recorded. It's almost like a notice of assignment of beneficial interest of a deed of trust.
Okay.
Kind of the same concept. Mm-hmm. So it's a notice of assignment of, purchaser interest in an agreement for sale. That gets recorded. And then at closing, assuming you're going to use a servicer, at closing, there's two warranty deeds that get executed. The first is from the seller to the original purchaser, and then from the original purchaser to the assignee, and you deliver those to the servicing company. You deliver the recorded agreement for sale to the servicing company, and you deliver the recorded notice of assignment of purchaser's interest in agreement for sale to the servicing company. And that's how you close escrow with an assignee, so that now it's very clear exactly, who's going to be making the payments, who's responsible for the payments, et cetera. You have your warranty deeds all set up so that, there's ability to fully perform and no hiccups there. And so you can fully assign, the agreement for sale prior to closing using that method and that process.
And I don't think you should assume that the form you're using has those assignment provisions. And I don't know how common it is to find agreement. Well, you can find anything online anymore, but I've seen scenarios where, a lot of times when you're working with escrow companies, they have form documents. You mentioned earlier, the agreement for sale wasn't just designed yesterday. It's been around a while. I remember doing agreements for sale for folks during the last Great Recession. Mm-hmm. They were coming up with new ways to do business because conventional financing wasn't working, and did a lot of agreements for sale. So it wasn't a new thing. And I recall seeing a lot of form contracts that the escrow companies would provide that were good enough in their own right for what they did, but they certainly didn't contemplate much of the time a creative finance transaction or a sub-2 deal. And so it's important to, if you're going to do it, make sure that you don't take for granted that the form just automatically has the assignment provisions that you need.
Yeah, and that's critical. I mean, I've seen transactions on the back end where people are, buyers through a traditional wrap, for example, subject to wrap, where they now want to sell it to a third party on a wrap, and the seller finds out, and the seller's like, no, you can't do that. And they're like, well, yeah, I can. I did it with you. Why can't I do it? And they said, oh no, the note and deed of trust that I have says that it's due on sale. And the note and deed of trust was prepared by a title company that didn't fully understand the nature of the transaction. And, you know, even though maybe their purchase contract or subject to addendum stated that the, you know, resulting wrap note and deed of trust would not be due on sale, it just, they used a form and nobody caught it. And now you have a due on sale clause that you otherwise did not want to have or need to have. So you need to make sure that the agreement for sale form that the title company is going to use is going to allow you to fully assign that agreement for sale either before escrow or even after escrow. You know, and it's critical that if you're going to assign it, that you put that a servicing agent in place so that it's smooth and you don't have any hiccups with a lack of a warranty deed or anything like that.
What other key provisions you think have the potential of getting missed in an agreement for sale when doing sub 2?
Yeah, the other, in my view, critical provision is making it non-recourse. You know, so you, especially if it's straight, like subject to where you're just paying the amount of the mortgage and you're not doing any type of seller carry, you know, there shouldn't be any recourse provisions in there. So you want to make sure that, you know, it's non-recourse, because the anti-deficiency laws likely don't protect you with agreements for sale as they do with, you know, traditional mortgages and deeds of trust.
Well, Sean, what else do you think the listener needs to know about the agreement for sale as we consider it in kind of trustee sale states and foreclosure states?
There was a third thing I wanted to talk about as far as the language. Oh, insurance is important. You need to figure out, okay, who's going to pay the insurance? Because technically the owner of the property is the seller. And so you can structure insurance a couple of ways, and I'm not sure there's any one right way to do it. But the first way is that the seller continues to have the property be insured because they're still the record title holder of it.
Right.
And then you reimburse the seller for that, or you pay it as part of the mortgage payment. I like having the purchaser being added as an additional insured so that the seller, you know, if there's a fire, the seller can't just run off with the insurance proceeds. So I would request as the purchaser to be named as the additional insured on that policy. And then as the purchaser, your personal property that you put into that, you know, home or that property, that's not going to be insured under the seller's policy, because you're not, you know, the insured. Under that, they're not insuring your personal property. Even if you're an additional insured, your personal property may not be covered. So you're going to want to get a personal property coverage similar to a renter's policy to cover your personal property. And you want to be the primary insured on that. And the seller shouldn't be listed or involved in that policy. So there might be some additional insurance you want to have in place. You know, renter's policies are not very expensive. Personal property policies are not very expensive because generally, you know, the value of personal property is not significant. And so that would be my recommendation for structuring insurance. So you need to make sure that the insurance provisions make sense and are consistent with what you want to do on that transaction.
All right, Sean. Well, good stuff. Good deep dive into agreements for sale. Like always, you need to check what state you're in. You need to engage an attorney, and to find out the pitfalls associated with an agreement for sale in your state, or if it's even allowed or permitted. Some states don't. And so you have a full grasp and understanding of the risk associated with that kind of transaction. But a real interesting an interesting strategy play when it comes to buying subject to. With that is our episode. Make sure to join us next week. We're actually talking about the ins and outs of self-storage. I'm excited about that episode. If you ever had an interest in investors who have dived into the space of self-storage and the issues associated with that should be a good episode. And we're going to get into the weeds on that. With that, make sure to join us next week, and we'll see you at the Collective at 3. Have a good day.
Have a good day, everyone.